Welcome, everyone. I'm Cary Coglianese, the director of the Penn Program on Regulation and a member of the law school faculty here at the University of Pennsylvania. I'm thrilled to welcome you to today's discussion about Bill Novak's new book, New Democracy, The Making of the Modern Administrative State. And for the next hour and 15 minutes, you're going to hear very much about this book, and I hope you'll be intrigued enough to read it. It is an important, vital history of U.S. governmental and legal developments from the close of the Civil War to the beginning of the New Deal, a period which witnessed what Bill calls the, quote, reinventing of the American state and reworking of the basic terms of American democracy. This book is simply a tour de force of the period, with chapters addressing citizenship, police power, public utility law, social legislation, antitrust, and administrative law. It's a book of U.S. history, a book of legal history, a history of governance, and an intellectual history about politics and social theory, about state and society, business and government, the individual, and the collective. It's a book that's very timely, too, given how many of its themes resonate today. Falling within the period covered in the book was, of course, the Great Flu epidemic of 1918, but other themes about citizenship, race, and immigration still resonate today. And unfortunately, the quest for equality and full participation in democracy remains a challenge with us today as well. It's also the case, as Bill has written elsewhere, that, quote, American administrative law and statecraft are currently ground zero for a larger struggle between regulatory history and constitutional mythology. So this is a timely book, a rich book, an elegant book, and one beautifully crafted. Consider just one sentence that describes the quality of the writing in this book. I quote a sentence with brilliant alliteration: moments of the American political have always owed more to majorities and magistrates than to either Milton or Machiavelli. To appreciate this book even more than I have been able to do in these brief opening remarks, and to expose the value of its lessons for today, I'm delighted that we not only have the book's author, Bill Novak, with us today at Penn and with us on this webinar, but we also have two greatly admired members of our law faculty at Penn who will be participating in what I expect will be a rich conversation about Bill's new book and what it means for us today. So let me introduce each of them and then turn the conversation over them and try to stay as much out of the way as I can. But let me also suggest that this is a conversation in which you, the members of the audience, can participate as well. Please enter any questions that you may have into the Q&A button down at the bottom of your Zoom screen. I'll be monitoring what comes in there, and will do my best to try to ask and get answers to as many of your questions as we possibly are able to in the amount of time we have. Let me now introduce our speakers. First, Bill Novak is the Charles and Edith Klein Professor of Law at the University of Michigan, where he is on the faculty and an award-winning legal scholar and historian. He's currently, though, a visiting professor of law at the University of Chicago, where he previously was a professor of history at the U of C and a research professor at the American Bar Foundation. An influential thinker in the fields of legal history, public law, and American political development. His previous work includes the People's Welfare, Law, and Regulation in 19th Century America, the prequel, if you will, to the book we're talking about today, in which Bill focused on state and local government in the period leading up to the Civil War. That book won the American Historical Association's Littleton Griswold Prize for the best book in the history of law and society. He has other works, including among them volumes entitled The Democratic Experiment, The State in U.S. History, and The Corporation and American Democracy. We're delighted to have you with us here today, Bill. Joining him on this panel and commenting on the book, first, my colleague Karen Tani, who's the Seaman Family University professor at Penn on the law school faculty. She's a scholar of the U.S. legal history, has broad interest in social welfare law, administrative agencies, and the role of rights in the modern American state. She is herself the author of award-winning book, The States of Dependency, Welfare, Rights, and American Governance, 1935 to 1972. And currently she's conducting similar path-breaking research about the history of disability law in the late 20th century. Finally, my colleague Christopher Yu will be joining us. He is the John Chestnut Professor of Law, Communication, and Computer and Information Science here at Penn, and the founding director of the Center for Technology, Innovation, and Competition. I'm very pleased that CTIC is co-sponsoring today's event, and extremely thrilled that Christopher can be with us. He is one of the world's leading authorities on law and technology, and one of the most cited scholars in administrative and regulatory law, as well as intellectual property, and the author of 5 books and over 100 other scholarly works. Welcome, Bill, Karen, Christopher. Bill, if I could turn things to you first to give us a basic idea, an introduction to your book, share with us what you would like us to have as a foundation going forward for discussing it. Then I'll ask Karen and Christopher to offer some opening comments as well. Bill?
Great. Well, thank you, Cary, for that very generous introduction. I'm much obliged. It's such a pleasure to be at this great forum to discuss my new book, and I can't wait to hear Karen's and Christopher's comments. So just delighted to be with you all tonight. I'll give this just a little bit of an introduction to the book, and then we can move on to discussion and conversation. So most of my legal history research to date has really focused on uncovering 19th and 20th century vernacular forms of American legislation, regulation, and administration. In contrast to pervasive myths about an original American legal political inheritance dedicated primarily to private rights, a weak state, constitutional limitations, and laissez-faire political economy, I've worked instead to try to uncover a deeper and I think strangely obscured history of American public rights, public law, popular lawmaking, and surprisingly energetic state regulatory and administrative technologies. This act of kind of historical recovery, as I think about it, has simultaneously required a substantial critical project, a kind of realist, cynical acid to strip away some of the myth, falderall, claptrap that has grown up around the supposedly ongoing history of an eternally limited, constrained, night watchman jural, ultimately weak American state. So New Democracy basically is, as Cary suggested, the second installment in that ongoing revisionist project on American law and statecraft, this book dealing with the period from Reconstruction to the New Deal. As Cary suggested, the book contains 6 chapters dedicated to 6 transformative legal developments in the law of citizenship, police power, public utility, social legislation, anti-monopoly, and then administrative law that together, I argue, amounted to the major transformation of public law before the New Deal. A transformation in techniques and technologies of legislation, regulation, and administration that ultimately made the New Deal possible. New Democracy is the book I actually committed myself to writing in the conclusion to my first book, People's Welfare on Common Law Regulation in the 19th Century. And Cary's right, fair to see it as something of a sequel to that earlier volume, now completing a legal history of American regulatory state from the first days of the New Republic to the New Deal. And in fact, this year, I've had the pleasure of starting work on a new original project, a prequel to it all. I'm going out of order in kind of Star Wars fashion, Volume 1, trying to retool as an 18th century historian to take a fresh look at the American Revolution, the American founding period, by examining again what legislatures, regulatory councils, and committees of inspection and safety, not just committees of correspondence, looking at what they're actually doing as opposed to what our more famous founding fathers were saying. The big six in Akhil Amar's words in his recent book, The Words That Made Us. The words that made us. In regulatory history, we look at some other things, and the American Revolution shouldn't be treated, committees of correspondence, as if it was some kind of literary event or a debate in academic political philosophy. There's a lot more going on the ground that I think historians are digging into. So there's a necessary continuity of theme across this trilogy as a whole, and my goal throughout has been to map and retrieve this alternative public law tradition of active governance and statecraft on the ground, in practice, in the United States from the beginning to the onset of our own times. So one question I think every author must first confront, when they're writing a book is, why did I choose to write this particular book? And here the question becomes, why in the world would I want to write 3 different books in this particular vein? And for me, just to be honest, put my cards on the table, the main reason comes from a recognition early in my sort of academic career that almost everything I was first taught in my youth about American history and the Constitution and legal history was not really wholly historically accurate. In the book, especially in Chapter 2 on police power, I associate early 20th century Democratic reformers with an intellectual philosophy called American pragmatism. I prefer to call it critical realism, which then also brings the legal realist elements in here. What I think of as a thoroughly modern, adult, critical, realistic perspective on the world. Unfortunately, for those of us who came of age at the tail end of the so-called baby boom, critical realism was no longer ascendant in the United States. Instead, in the wake of intense ideological struggles against totalitarianism in World War II, Cold War, we late boomers were force-fed a steady diet in school of American exceptionalism. Here, American history was portrayed as a special city on a hill, morning in America, alternative to the regulatory police state traditions that were then busy ravaging 20th century Europe. American history, comparatively, as an almost sacred freedom narrative, emphasizing the U.S. fundamentally as a land about individual rights, self-reliance, voluntarism, entrepreneurship, anti-statism, when the state is addressed at all, private property, liberty of contract, and the free market. Now, of course, you all know this as something of a cartoon, but it's amazing the degree to which this caricature makes its way into the core of 2 generations of some of our most sophisticated American constitutional and political histories. And in my opinion, this post-war vision, this exceptionalist vision, still accounts for some of the wild misconstruals, myths and fantasies, as Cary introduced them, that continue, I think, to fan the flames of some of our most volatile political disagreements today, right? Anyway, like most boomers, for a while I drank the Kool-Aid, and quite literally back in the, we drank Kool-Aid, things that were artificial, prepackaged, anything instant, right? That's what we did. But as I started to seriously more dig into the actual empirical record of American history on the ubiquitous, it's just not hard to find, and I'm finding this in the 18th Century Project as well, ubiquitous legal and state regulation of social and economic life in America, I just found more and more overwhelming evidence that the historical reality on the ground was decidedly different from the reigning mythology. Couple examples. I don't cover these in this book, but just to set the context, most obviously the policing of slavery, immigration, the removal of native peoples and free people of color, not the products of laissez-faire, not the products of a society with a special predisposition to leave people alone. The historical record is different. I like to remind folks that in John Stuart Mill's supposedly libertarian classic On Liberty, his favorite examples of governmental overreaching had stronger roots in the U.S. than Europe. Liquor regulation, Sabbatarian laws or Sabbath laws, Sunday laws, the persecution of the Mormons. One can hardly explain the rise of American military might, American commercial development, yet alone the role of the prison or the death penalty or racial segregation, the growth of executive emergency or war powers in American public life by continuing to cling to an essentially Cold War fable of exceptionalism, voluntarism, and rugged individualism. The myths have to go. The reality is different. One of the goals of my books is just to speed the process along where we could get back to a more realistic conversation of what actually went on. So in contrast to the secular theology, the book excavates an alternative American legal historical reality. In place of contract, property, and tort as central building blocks of American legal modernity, public rights, public law, robust public regulation take center stage in New Democracy's account of the actual practical workings and pragmatic public policy demands of a rapidly modernizing society and economy. Such distinctly public law categories were the creative workshop of progressive legal reformers committed to crafting new legal technologies, and their innovation is kind of stunning, of public provision and public works so as to help Americans build a more substantively democratic way of life. The 19th century patterns of associative governance, common law, local regulation that I describe in my first book as the well-regulated society were displaced by a reconfiguration of the relationship of state, law, economy, and society. A newer central nation-state consolidated around new interventionist conceptions of legislation and regulation radically extended its reach into American life. And together, these changes, I think, amounted to a transformation of governance that arguably is the most significant legal political development of the 20th century. It moves to the center of American history, a modern legislative, administrative, regulatory state of a vastness and complexity still being reckoned with in new law school courses on legislation and regulation, so-called LegReg, or increasingly novel still, networks, platforms, and utilities, an attempt to kind of return regulated industries to a central place in the American law school curriculum. This governmental revolution left no aspect of modern American life untouched or the same. To the contrary, it ushered in an American legal political modernity with which many Americans remain profoundly unreconciled to this very day. I repeat, profoundly unreconciled to the nature of regulation and its role in our lives. From the anti-statism of Ronald Reagan's first inaugural, right, government is not the solution, government is the problem, to the Tea Party movement, to today's anti-vaxxers, anti-maskers, we are all only too aware, I think, of just how many Americans remain profoundly, sometimes militantly, unreconciled to the kinds of modern governmental, economic, and social regulations pioneered in this progressive period that are the subject of the book. And yet when we go back to the heights of reform in 1912, all three candidates running for president, just an illustration, Taft, Wilson, Roosevelt, very different people, identified as progressives committed to more, not less regulation, more corporate regulation, more labor regulation, yes, as Cary indicated, more health regulation, less benignly as well, more morals regulation and more social regulation. One reason the New Deal activists called themselves liberals rather than progressives, to get away from prohibition and other forms of morals regulation. What was going on in this distinctive and different historical period? What lessons might it hold for our own crisis times? This book results from my simple effort to kind of go back and re-examine the primary sources rather than relying on more ideologically inflected secondary syntheses so as to investigate some of the deeply rooted reasons for the long, slow rise of the modern regulatory state in the first place. Why did we build it? What were the public problems to be solved? How did they attempt to solve them? I mean, that's basically the structure of the book. Okay, so I should close and wrap up because I'm really eager to hear from all of you, and particularly our two distinguished commentators. But just to give you, just one more closing thought about one of the takeaways. In the introduction and the conclusion of the book especially, I try to make a case for and underscore what I see as the radicalness of progressive legal reform. Stunning in comparison to our own times, where whether it's in Congress or through constitutional amendment, we feel the best we can do are small technocratic nudges right on the public policy regime. These people thought differently, right? The progressive social democratic reformers in the book were not mere tinkerers. They had little patience for accommodationist, incremental, technocratic policy moves as they had for reactionary laissez-faire apologetics. Theirs was a radical, substantive, transformative policy agenda. Think about it. 4 new constitutional, when you get constitutional amendments, something's going on in a historical period. The invention of innumerable new agencies of public administration, the independent regulatory agencies, now under somewhat of a kind of critical assault. Let's figure out why we built them in the first place. The ICC, the FTC, Federal Reserve Board, the Federal Power Commission, the Federal Radio Commission. This is where this is built, notably before the New Deal, right? Heavy lifting is done before Franklin Roosevelt becomes president. The wholesale replacement, we should think about this too, of common law systems, 19th century common law systems in favor of these new superstatutory regulatory administrative regimes, throwing out the old common law of master and servant with respect to workers' injuries, throwing out the old poor laws, as Tani has written about so wonderfully, in social service administration, trying to create a new system of social welfare provision that didn't depend on these traditional technologies, to throwing out municipal administration via municipal law via justices of the peace, right? Michael Wilrich has a wonderful book on creating a modern metropolitan court system to deal with justice in American cities. Progressive solutions rested on a seriously thought out, rigorous underlying philosophical pedigree, deeply rooted in pragmatic, critical, realist, and social democratic commitments and aspirations of the day, and I think it holds some lessons for us today. The book has lots of content on progressive mobilization around 3 issues in particular, and I'll close here. An issue of power, the rise of concentrated corporate economic power and its subsequent abuse. Second, an issue of democracy, the consequent corruption or capture of American politics by such special corporate interests. And by the way, they're not worried about the regulatory agencies as much in terms of capture. It's the fact that the state legislatures and the courts and the executive, the governor's office, they see as captured. And the regulatory agency is seen, the independent regulatory agent is seen as a democratic antidote to a corrupt political status quo. Thirdly, the issue of equality, increased focus on socio-inequality, precarity, deprivation on the ground that seem to betray American fundamental democratic commitments. I'm sure you'll agree with me that such issues are only still very much alive today. And so my hope is that this history might provide some tools to begin to think about new ways of combating some of these persistent problems, corruptions in American legal, political, regulatory life today. So thanks.
Thank you. Thank you very much, Bill. And share with you the first comment that has come in already on the Q&A function. It's a 1-word comment, and I think we can all agree with it. Wow. Thank you. Thank you very much for that opening. And I will encourage any audience member to share your comments or questions in the Q&A function. But let's turn to Professor Tani for her comments about this book, its significance, and your own take on that period and what we should take away from Bill's scholarship.
Thank you, Cary. And first, I'll just say what a pleasure to be part of this conversation. I'm going to focus on the contributions that this book makes to my fields, the fields of legal history and the history of American governance. And I first just want to underscore how excited historians were for this book. And it has to do with how much we all loved Bill's first book. Here's my own dog-eared copy of The People's Welfare. It remains a staple of graduate student reading lists. My own copy is falling apart from how many times I've revisited it. And The People's Welfare, a few things that it did. So the first is just kind of methodologically, it taught us how to look for the state. So it taught us that if we want to understand the American state, we shouldn't look at the size of the federal government or the number of people on the federal payroll or the pronouncements of the Supreme Court, but at the actual day-to-day practices of people with official power, just a hugely important methodological innovation. And from that perspective, as Bill said, we see that the American people were actually quite heavily regulated in the 19th century, that notions of the public interest regularly took precedence over private property and individual rights, and that this was acceptable and expected. So in short, this notion of laissez-faire government that I think is still hanging around, this notion that dominated the 19th century, that's clearly a myth. The People's Welfare also taught us that the state operates differently in different eras. And for me, this was just a hugely important move. So Bill, as you can tell, is a synthetic thinker, and he sees the big picture. And again, one of his great innovations was to kind of show us this 19th century state that governed a lot. It just governed differently. And then to show us that at some point there is then a transition to this more modern and familiar counterpart, this modern American state. And where the book left off, as Bill said, is, well, how exactly did this modern state operate? How did it emerge? And for that, we had to wait for the sequel. So we've been waiting with bated breath, and now we have it. So here is what we learn from New Democracy. So first of all, I think Bill is really careful to say that this modern American state, it doesn't emerge all at once. It doesn't emerge overnight. And to the extent that it displaced this prior regime of governance that I've just described, it did so, again, over a period of decades, never without contestation. That said, and again, I think this is kind of Bill's brilliance, is at distilling key features or sort of key pillars of this new architecture of governance. We see some key features in place by the first decades of the 20th century. So one feature is a more robust nation state, central nation state. And it's a nation state that's connected to individuals in a different way via the concept of national citizenship. And as Bill shows, that's really new in this period. Another feature is a more ambitious understanding of the kind of problems that government had the capacity to address, and also the scale at which problems should be tackled. So I think something like national old age insurance is a good example of the kind of governance work that would not have been possible in an earlier era, but came to seem possible and indeed imperative in this modern period. And there are many other examples in the book, ranging from antitrust to more darkly like social hygiene regulations. New Democracy also brings into view a distinct set of governance tools. Again, these are the tools of the modern American state. Legislation and administration become more important. And within those realms, there was a new preference for generality and uniformity. The police power, this is kind of an old tool, but this expands dramatically, Bill shows. Also, we get the legal concept of the public utility and so on and so forth. So the book also just, again, shows us really closely and clearly this new set of tools. The seeds of some of these claims were present in Bill's older work. So in some ways, some of this, if you're a Bill Novak fan, not all of this would have been surprising. But I'll tell you what I did find, just really novel and interesting about New Democracy. And it is this theme that Bill sees running through all these changes in governance, and that is democracy, specifically what he calls substantive democracy. And I think he's really careful to separate that from sort of our more conventional procedural electoral democracy, substantive democracy. So this, in my words, to paraphrase, this is an aspired for condition in which necessary opportunities and resources are in the reach of every individual. And the goal of government is to make it so in a manner that is both equitable and effective. And he sees this ideal running through these different realms of governance that he illuminates in the book. To put my cards on the table, as Cary said, I'm a historian of the modern American state, and I study this period, and I just missed this. And it feels kind of embarrassing now. In my work on the rise of a more modern system of social provision, I wrote about administrative governance and the centralization and nationalization of authority. And I wrote about the kind of citizenship that Bill documents in this book, but I didn't describe any of this as fundamentally democratic. And again, I just think this is so important that Bill's book does this so powerfully and persuasively. And I think he also shows us the danger of that oversight. And maybe we can talk about this, but I think it plays into the hands of people who would have a much less regulated form of capitalism, a thinner social welfare state, a government that outsources basic functions to the market. And that is because people in that camp with those preferences, they love to cast the modern American state, especially the administrative state, as undemocratic and therefore illegitimate. So Bill in this book really kind of flips the script by arguing that the modern American state and its extensive administrative apparatus, that really responded actually to perceived crisis in democracy. So these efforts represented an effort to save democracy, not to override it. So I think in our conversation, it could be fun to talk a little bit more about what Bill alluded to in his remarks, which is kind of this historiography question of why have so many scholars missed this. We could talk about, is this about sources, like the type of evidence that scholars have used versus what Bill used? Is it about ideological or political commitments and how those can prevent us from interpreting evidence in the best way? Provocatively, I'll say, is there a story here about erasure, about maybe later actors or scholars kind of undoing or obscuring some of the governance work that Bill describes? Okay, so I'm going to close this comment with a few questions. I know these are ones that Bill has heard before, but I think they would nonetheless be interesting for this convening. So first, what do we do with the fact that, on the one hand, so many facets of this modern American state, they came into being because of a vision of substantive democracy, which sounds really great. But on the other hand, and Bill mentioned this in his comments, exclusionary and anti-democratic impulses were also clearly in play in this era. So, yes, we have creative and ambitious regulation of business in service of the public interest. We see the birth of the modern welfare state, but at the same time, modern technologies of governance are being used to subordinate and exploit all kinds of people. As Bill mentioned, this is an era of colonization, forced Native American assimilation, Jim Crow. So the question here I would pose is the modern American state fundamentally a democratic state? Or is the modern American state a regime of governance that can be democratic, but did not and does not have to be? Second question, this book stops with the New Deal, and in doing so, it offers a powerful and I think persuasive critique of scholars in my field who have overemphasized the New Deal in the history of the American state. So again, the way that Bill periodizes this, it's a really useful corrective, but it kind of raises this interesting question for me about how Bill would characterize the post-New Deal state. And I'll say some readers of this book have interpreted Bill's modern American state, the one he describes in New Democracy, as essentially one and the same with our current regime of governance, right? They have said, oh yeah, you've just described the regime that governs us today. And I think in many ways that's probably right. But I think in the book itself, or at least my reading of it, Bill actually stops short of making that claim and in fact acknowledges the ways that our current regime of governance is impoverished relative to what came before. So the question to Bill is, how would you describe the current American state? Is it fundamentally the same as the state you illuminated in the book, or are we living under a different regime in some respects? Thank you.
Excellent. Thank you very much. One of the in the theme or category of myth busting, I was struck, and Bill, you may have this statistic more readily at hand than I do, or maybe others do, but we spent a lot of time focused on the so-called Lochner era in talking about U.S. Constitutional law and protection of the right of contract or property, and yet. And this is the statistic that I recall in your book, was something like of 300 or 350 different court decisions that dealt with state regulation of business during that time. Only 5 actually came down the same way as the Lochner decision did, or something along those lines. So it's a concrete example of this search for data and evidence. Did I get the numbers approximately correct, Bill?
Yeah, these are these Charles Warren figures, who was one of the first people to go back and sort of actually when there's all this rhetoric, right, about the Lochner era and the court actually stifling regulation, actually decided to sort of count the opinions. And he does separate them according to either a due process claim or some other kinds of issues of kind of taxation or eminent domain. And so some other laws go down, but nowhere near, as you've suggested, anywhere near enough to suggest that the Lochner case defines the era. I would argue it's the heyday of public utility regulation. We should all be talking about the public utility era and leaving Lochner for another day. Yeah.
Well, maybe that's a great segue now into our next commentator, exactly. Professor Yu. Let us, hear your thoughts as a scholar of regulated industries and antitrust. We're looking forward to your comments on Bill's book.
Well, thank you very much. And thank you, Bill, for writing such a magisterial tome. And it was something we've all enjoyed reading. As Cary just said, I am a scholar of regulated industries and antitrust. So The social legislation aspects I'll leave to Professor Tani and to other people who study that more, and that's really the grist for my mill. And so I wanted to thank you because I think that you really, on the main themes, I think that I largely agree and really appreciate the sort of the corrective, which is I do think that your basic points that the role of the state was much more extensive earlier on than many of the conventional narratives would have us believe. And I think that that's something that's very real and is incredibly beneficial. Second, I agree entirely that narrative goes back prior to the New Deal. I'm a huge fan of the Progressive Era, and if you look at the foment and going back to the Granger movements and all that, there's something very, very important going on here. And we can fight over Lochner and different things. One of the great puzzles to me as a student of regulated industries is if we're looking for affirmative rationales, why are we talking about constitutional law? And the answer is because it was then perceived as the default under this paradigm was you can't regulate unless generally, but we created this exception for these things we call public utilities, and we discovered that we developed an extremely expansive notion of them over time. And eventually, what we're going to see in West Coast Hotel with respect to economic regulation generally, it collapses. And then, in fact, we persist with regulated industries to a certain extent with takings clause and confiscatory rates, and that collapses with a Supreme Court decision called Hope Natural Gas versus FPC in 1944, where basically law gets out of this business altogether, where if it's economic regulation, whatever legislatures do is going to be okay. And the roots of this go way back. And it is it's a creeping phenomenon, which I think you track very, very well. And the third thing that I really love about what your book does is you make a continuity between antitrust and regulation, which is, you're saying there are multiple sides of the same coin of regulating business, the regulation between government and business. And I think that's often overlooked, but in fact, I think we've gone full circle. When you see certain Supreme Court cases like Trinco, they now buy into this idea that we have to interpret these two bodies of law together in order to understand what the real impact is going to be. So I think that's all great. I could join Karen. We could spend our whole time just throwing encomiums on you. But let me try to get a conversation going. So what I find is interesting is the role of the state, is, I think there is a pivotal change that you identify. Part of it's interesting is, I don't, on the economic side of the house, more so than the legal side of the house, it is difficult. I mean, it is the laissez-faire people, the Manchester School and the people at Harvard, those economists were very, very strongly in that persuasion. And there's an interesting vector, which is the study of political economy really died in the U.S. And so if around the turn of the century, if you wanted to study political economy, you had to go to Germany, which had a very different state-oriented, coordinated vision of cartels, for example, state-directed cartels and the like in the Prussian mode, including Richard Ely, as you notice, one of the major figures who trained John Commons, heck, he trained Woodrow Wilson, and founded the American Economics Association. So, I mean, there is, and he's not just him, there's a whole bunch of these scholars. So there's an obvious vector where the study of political economy, even though it was curbed in economics departments here, continued in the continental Europe. And there was a direct vector we can see why people became much more interested in interventions that gave more capacious room for the role of the state, which I think is clear. If I were to raise two main, one quibble or one limitation and one possible expansion, I find the book's argument in favor of a broader role of the state stronger than the case for it being a democratic move. And I think the democratic move clearly has support, and there's a lot of things that are consistent with it. But there are some interesting threads in the progressive era which to me weren't necessarily democratically motivated. So the first one is the tremendous progressive faith in technocracy. And in particular, this was the rise of Taylorism. And what we forget is Taylor was Ely's student, and in fact, Taylor became a great fascination for Brandeis and other actors, becomes reified in Landis and this great reverence for expertise. And you can talk about technocracy in many ways, but I don't know that that's a democratic move. In fact, Landis wanted to remove this from politics, wanted to remove decision-making from politics. And I keep thinking about the Brownlow Commission's, characterization of this. We need, these technocrats with passions for anonymity, who actually were going to, if all the lawyers and the politicians would just get out of the way, we get a much better outcome. Now, there's a way you can cast that as democratic, but there's some other thread where you're really relying on science more than institutional mechanisms, which I think eventually dies, but was an important thread for progressive thought in the 1920s. I'll confess, by the way, I am writing something on public utility, so I presented at our law school in June, and I don't have it in writing yet, so I'm actually going to foreshadow a couple things. One of the great things that I loved about this is the role of religion. So both Ely and John Commons' student, who were major figures, as you note, in this movement, were also both leaders in another religious movement called the social gospel, which was an attempt from Protestants to say, we've been spending our whole lives trying to save ourselves, we need to save society. And so part of the motivation, arguably, complementary with the democratic motivation, but there's a much more complex set of schools going here. And then the other thing there's another lens on the motivations, which is really is highlighted to me by the choice of remedies. Even if we're going to have a bigger role for the state, why the regulatory commission? That's the hallmark of the public utility movement. Because the alternative was municipal ownership. And in fact, as you note, Ely supported it, but actually he changed his mind and shifted to commission regulation, as most progressives do. And I can see at least three interesting threads that are sort of laying through here that aren't really about democracy directly. They're all related. But one, anti-communism. This was the time of the Soviet Revolution about to happen in 1917 and the rise of communism. And in the choice between commission regulation and municipal ownership, public ownership started to look too much like communism. And a lot of the organizations here, the one thing they didn't want to be seen as is being affiliated with that. And so you start to see in the choice of mechanisms, the choice for public utility regulation over municipal ownership within the state is, a toolkit is interesting. The second thing is there's a really interesting set of writing about the problems with municipal corruption, going back to the muckrakers. So you can get statism, but is it at the municipal level, is it the state level, is it the federal level? And part of it, there's a sophisticated political economy where they chose to do it at the state level because they didn't trust the municipalities, even though they are states. And then there's a good old-fashioned capture theory article. There's an argument, which is actually a person who is a major electric power utility executive, who you single out in your book as called named George Insall. You mentioned the Insall monstrosity.
Yeah.
He actually used like the National Civic Federation and other things as a cynical move to embrace commission regulation to avoid municipal ownership in exactly the ways that we worry about. And of all things, that's definitely not a democratic move. So I don't think anything's inconsistent with what you're saying, but there are some really interesting threads here that don't always go there that we can try to weave and may not, I would say, a lot of them didn't bear fruit, and I think that they don't necessarily contradict you, but it makes the narrative a little more complex in the ways that historians love, right? I mean, there's a more interesting story that needs to weave here. The second major comment to refine is you make a really insightful statement, which I really like, which is we have this public utility ideal which makes an integral part towards giving the state a larger role. And then we have, as we said, it largely dies. Judicial oversight of this goes away with West Coast Hotel and Hope Natural Gas. And we see this pivot where it's just economic regulation. And in your book, you say we need to shift. There's a shift between public utilities to regulated industries. And in general, regulated industries, you can pretty much, we think the government can probably do anything it wants. Certainly the state can under its police power, federal government under the broad commerce power. This is going to be pretty broad. But what's interesting is I like that move because the defense for the state goes to the regulated industries. The distinction now, the public utility moniker is now associated with a distinctive suite of remedies, including entry and exit restrictions, duty to serve, tariffing, line of business restrictions, which does not have as happy a history. in the sense that there are, ups and downs. But I will tell you, tariffing, even in the 70s and 80s, we were trying to find alternatives because there's all this literature about how it's inflationary, it's distorting towards capital-intensive solutions and all these other things. And that, in fact, we see, even if we acknowledge the government has plenary power to regulate, whether they choose the public utility suite of remedies is a discretionary question. It's no longer a legal or a constitutional issue. Legislatures have full authority to do it. But it changes the question, if you have plenary power to regulate, when do we use this? And what I really found interesting in your book is that you mentioned Rex Tugwell of the fine University of Pennsylvania called for making banks public utilities, as does Brandeis, as does a number of scholars over the years. That's a step we've never taken. And we see Wyman actually called for as you point out in your book, all trusts as public utilities, a step we didn't take. And another mention, you quote, actually don't the proposal, but you quote Nicholas Bagley's support for public utilities, in his case for healthcare, which is also a step we have never taken. These are obviously key important industries. So what I find lurking in this is another question of, even if we establish plenary power of the state to intervene in a way we never had before, what did the history tell us about when we choose to use the public utility suite? What have we learned about in practical and pragmatic implementation? Because you have it's largely a political question, the power, and it was a question of when is that the right modality to use? And I think that's a big question that's coming around now. I don't think it's coming around in big tech. So as you know, Lena Khan called for public utility regulation of Amazon. And for those who are following this, there's an Ohio case where they're actually litigating whether Google's a public utility, which failed at the trial court level. We'll see what happens. But there's a separate question to me, even if you make your democracy and state-oriented claims stick, when is this the right tool, despite its critical role it played in establishing the legitimacy of a larger role for the state? What have we learned now for public utilities as a modern conception about when we deploy them? Those, I think, are more on amplifications than what I would call criticisms. I love the work, and I look forward to having a wonderful discussion with you now for the rest of this event.
Thank you very much for those comments. And Bill, why don't we turn it back to you? You've got a fair amount there that you could respond to as however you would like.
Thank you for those two wonderful comments. There is a buffet of important ideas on the table, so thank you both for putting them all out there. I won't be able to address them all without going away from this being a conversation. So I'll take a couple of stabs at them, and then hopefully we can kind of converse about them as opposed to have me give a long answer about them. But I thought one that was in common with both Karen and Christopher's comments is what I mean by democracy and what are the kind of limits of that democratic orientation in this period. So I might just start there. And your approaches were a little bit different. I heard Karen talking about quite correctly, right, that I try to move towards a more substantive rather than exclusively procedural conception of democracy, that this is what they said they were about. It's what John Dewey said he was about, what Jane Addams said she was about. And that's, obviously, on today of all days, voting is important. The processes of democracy and the mechanics of democracy are important. But when these people thought about democracy, they thought about it as a substantive vision of a way of life that required, in a kind of historic way, relative equality among the citizens, among the people who are doing the self-ruling and the self-regulation. That was not going on in the late 19th, early 20th century. And one of the things that I sort of discovered in doing the research, the incredible lack of social provision, or the crisis of social provision, by trying to bring 19th century local techniques into the late 1930s, it was disastrous, right? And so Robert Fogel, the Nobel Prize winning economic historian in Chicago, it's just later in his career, just did some incredible work on what deprivation looked like with respect to life expectancy in this period, with respect to caloric intake. I mean, people are not eating enough. They're putting out members of their family, their own children, for certain periods of time because they can't afford to feed them. They are ill, they are unhealthy, and they're not living very, I mean, this is a real, and then you have huge disasters like Triangle Shirtwaist, where we realize that women are being locked in buildings, and disasters are happening in the workplace under these conditions. The food supply, I won't take you back to the jungle, but there's a reason we invent the FDA, and it's because the food supply was, so there are disastrous substantive problems on the ground in this period that seem to be creating a very unequal and really a society in crisis. And so substantive democracy, social provision is seen. There's a lot of voting in this period. It's not solving the problems of the people who are living very, very short lives. By our own standard, it's just, I don't have the exact numbers in front of me. They are actually in the book. But life expectancy in this early period, some people think about a golden age of laissez-faire. Nonsense. You don't want to go back to living in that particular period as compared to our own. So a lot of these innovations, I think, we're trying to just get a healthy level of provision and well-being and way of life and opportunity for most Americans. So that's a little bit different from Christopher's orientation towards the democratic. You're quite right. Obviously, Christopher, Taylorism is a really important part of this period. Walter Lippmann and his notions of mastery and mastery of public opinion, his distrust of democracy is a part of this period. I take more, I learn more from John Dewey and Jane Addams again, who I think have a very different definition that democratic administration need not end in kind of scientific technocratic administration. We need expertise when we can get it, but as John Dewey said, he debated Lippmann at length on this point, right? We are not just going to give governance over to the experts in educational administration. There has to be room for the teachers themselves. There has to be room for the pupils. There has to be room for the students. Constantly working to create those sorts of opportunities. Actually, I learned over the weekend, John Maynard Keynes actually had a similarly democratic conception of administration, embracing technocracy and technocratic expertise, but always insisting, right, that there be sort of democratic mechanisms for inputs. Dewey's famous phrase was, yes, the cobbler might be expert, but it's the person wearing the shoe who knows where it pinches. And that was his way of saying, yes, we need expertise, and then we have to consult the people and find ways to consult the people relatively constantly. I'll just say one more turn here with respect to why they felt regulatory agencies could be a site of democracy. It's clear in the primary sources, right, that they don't believe democratically elected mayors in big cities with huge turnouts. They are not acting democratically in this substantive way. And in fact, they're in the hands of the lobby, which is the railroad lawyers who are in the lobby of the state legislatures. Charles Francis Adams writes some wonderful books on just how deep the political corruption was. Democratically elected officials, but acting in ways that betrayed the people over and over again. Jane Addams in Municipal Governance says the same thing in Chicago over and over again. So they see, I think, the Regulatory Commission, right, they go to the Regulatory Commission as a place for more democratic input. And Charles Francis Adams is pretty explicit on this, and even with respect to the Illinois, one of the first state railroad and warehouse commissions, the Illinois State Railroad and Warehouse Commission. The idea is, right, that the farmer, worried about a discriminatory or corrupt railroad rate, a real gouging railroad rate, what recourse do they have in the traditional mechanisms, the traditional three branches of governance? They can't go to the courts. They're not going to beat the railroads in court over a single discriminatory rate in downstate Illinois, right? They can't go to the legislature because the legislature is in the pockets of the railroads in this particular period. Good luck with going to the governor, right? I mean, this is just, these other avenues are blocked. So the Railroad Commission, yes, we will have some experts there, but the goal of the Railroad Commission is now to take the petitions, the complaints of the farmers around the state, right, and begin to process them and provide a democratic access point, a democratic input point that now these ordinary people have to bring, and we still do this in notice and comment rulemaking, perhaps not as effectively, but create independent agencies as a new site of democratic access at a time where people are distrusting the democratic nature of the main branches of government. Is Charles Francis Adams under the illusion that The regulatory agency, as Christopher said, could be, no, he says explicitly, of course the regulatory agency can be captured as well, right? It's a new site. What can we do? Well, time to go back to the progressive, innovative drawing board and draw up all of the new checks and balances that we can on the regulatory regime, right? More checks and balances to prevent regulatory capture as well as legislative and court capture. And that was certainly the case, in the Insul monstrosity. Did we give up? No, we passed the Public Utility Holding Company Act, which is one of the most extraordinary, I think, climaxes to this tale, this long tail, as Christopher suggested, of kind of public utility innovation. So let me stop there so as not to filibuster and see if we can't have more of a conversation.
We're also getting some great questions from the audience too. So I appreciate that. And if anybody else wants to chime in on the Q&A function, please feel free to enter a question. But let me start with two questions that have to go to the conventional wisdom that you are writing, with as a backdrop, and the myths that you're busting here. And I think the questions here may be directed most at you, Bill, but I would invite Karen or Christopher to weigh in too. The first question is, well, what accounts for the massive traditional misunderstanding of the American state that you're correcting in your book? Is it a myth that was propagated by conservatives who wanted to depict an extensive state as a recent perversion of our history? Or does it reflect inadequate scholarship on the American state, or something else altogether?
Great question. I've begun to talk more about, even though this book stops before the post-war period, I've begun to talk about it more because people are really intrigued by this question, and it's forced me to kind of think hard about how these myths get constructed in the first place. And it's why I added those few comments which are not in the book, but about American exceptionalism, about a Cold War anti-totalitarian vision of Americanism, and American anti-statism, if you will, that grows up in that post-war period that I think is really strong. And I do think that involves a de-democratization of American history. That is a period where historians, legal and constitutional, start to talk more about liberty, freedom, voluntary. I mean, as Karen put it in her remarks, there is a kind of great erasure, or kind of forgetting, a conscious forgetting of these earlier traditions. Public utility, I mean, Christopher is exactly right. It has this deep roots in common carriage, in the law of innkeepers and the like, and it goes back to medieval England. But somehow these traditions were kind of raced in a moment of freighted ideological necessity. And actually, American pragmatism and realism don't do very well in this particular too, right? They're seen as too weak to create a kind of fighting faith that we needed to battle, right, the kind of police states of the totalitarian regimes that we were taking on in World War II and the Cold War. So I think that is a moment, and Richard Primus has a wonderful article on this in terms of its effect on constitutional law, that this period was really determinative. Ed Purcell has a book on crisis and democratic theory, that something happens. Robert Maynard Hutchins goes from being, one of the deans of one of the great realist bastions of American legal education, Yale, to coming to the University of Chicago and starting a great books curriculum and teaching undergraduates the great absolute fundamentals from Plato to NATO, that a return to kind of fundamentals and formalism in that particular period. So I think that is the moment. I think there's a complex history that needs to be written there. There's the role of kind of philanthropies. I mean, Harvard's history department, the Charles Warren Center, receives philanthropy to start a center of liberty in this particular period. And Oscar Handlin and then his student Bernard Bailyn and Gordon Wood begin talking more in terms of kind of liberty and freedom, rather than these kind of democratic and statecraft. And the alienation of the state is actually a major theme of their early American history. In Chicago, there are the Walgreen Lectures, where Charles Walgreen comes in and also tries to begin to affect and change the way we talk about kind of American history. And then there is, Friedrich Hayek is there in 1939, talking about capitalism in the state in a kind of new way. There's a move away from the institutional economists, Ely, Commons, Veblen, who dominated the early 20th. So I think there's a good faith intellectual effort that begins to search for new ideas too. But together, these forces really create this kind of erasure where, public utility might not be the absolute final answer for some of our problems today, but boy, we're rediscovering some aspects of that toolkit that we kind of, I would argue, forgot about, at least not people who are doing expert work in regulated industries, but many people did forget about pieces of that toolkit, and I think they're being revived in interesting ways today.
Another benchmark kind of question then about this conventional wisdom, using that as the benchmark, that is, like with a lot of conventional wisdoms, can be an easier target to undermine. And that's not to diminish in any way how powerful this is. But the questioner asks, after making that observation, wouldn't a more satisfying comparison be to, say, compare the US state with that of Northern European countries or even Great Britain? How do you think the US state would compare on that kind of assessment as a and I guess it would have to be either around the period that you're writing, what's happening in Europe, or even today, certainly, where are we?
Yeah, so that I think that is part of the history that we've forgotten. But prior to this change in ideas, circa 1939 and into the post-war period, there was widespread. Daniel Rogers has a great book on the Atlantic crossings, which suggests what a transatlantic dialogue this era of social democratic reform from the late 19th through the early 20th century was. Americans are going to conferences in Europe. Europeans are bringing ideas to the U.S. There's a kind of constant flow of ideas. John Commons, when he begins to move from Wisconsin's Public Utility Commission, a railroad commission, to then he has this aha moment. And he says, my gosh, why can't we do this with labor relations as well? And the first thing, it's going to be the Wisconsin Industrial Commission. The first thing he does is send a graduate student to Belgium to figure out let's see what these Europeans are doing with respect to their reconfiguration of labor regulation. And it goes into, it has direct consequences both in Wisconsin and then a precedent for national innovation in this regard. So I think there was a period where U.S. policymaking, U.S. thought, there's a new book out now on the Cambridge pragmatists, and so this is that even England might have been partaking more of this supposedly distinctive American pragmatic tradition than we thought. So that there is a lot more, I think, symmetry in some of the Jim Kloppenberg's book, Uncertain Victory, talks both about ideas as well as policymaking in this period, and sees just a lot of European American cross-fertilization of ideas and institutions. And then we begin to develop this notion of American exceptionalism. And American studies is invented as a field in the kind of post-war period, precisely under an idea that we need more Americanness in our curriculum. We need to study American. We need to assert American values. Purcell ends his book by suggesting in this period that America itself becomes a normative concept. Henry Luce of Time says this is going to be the American century. And that's a different style of thought. And I think that's a partial reason for some of this, for getting this actual, more comparatively rich, robust discourse and also political sharing that went on, policymaking sharing in the earlier period.
And I guess a third question in the benchmark category, and here I certainly welcome comments from anyone, because it's about how to factor in race into the analysis and interpretation here. And Karen, you mentioned Jim Crow laws, and I guess it's maybe this is prompted by a member of the audience to ask this question, but I might even take it a little further to a methodological perspective. How do we write about that period as focusing on progressive ideas when nevertheless there still was and still is to this day so many structural barriers to equality in the United States.
So I would love to hear more of the way Karen's thinking about this, but let me just, as she said in her comment, you know, the substantive democracy I'm talking about here is an aspiration, rather it shouldn't be mistaken for a reality. As Christopher suggested, there are lots of people with different ideas from the people I highlight in this particular book. I did try to start with that citizenship chapter to foreground this struggle and the relative progress that was made, both with respect to anti-slavery, but also the victories of free people of color over discriminatory state police power laws. And Kate Mazur has told that story in incredibly great detail in her new book as well. I also try to do it a little bit in the social regulation chapter, the social hygiene stuff that that Karen mentioned. If I had more time before pivoting to the 18th century, I would have loved to have added a chat. I do think there's a response, okay, so that there are limits to this vision, and the Woodrow Wilson administration's excesses with respect to building up a national emergency state around World War I and the deportation mania and the immigration restriction that was all part of that. Some of the first people to respond to that are some of the same progressive coalitions, you know, that were assembled, that were doing this work of kind of social provision and public utility regulation earlier. And so it's not an accident that both the NAACP and the ACLU kind of find their sort of birth moments in this period with some of the same coalitions of progressive activists across the range of various kinds of groups that are represented in that effort. It's really, so I would have liked to have done more on, there would have been another chapter, the book would have gotten a little too long, I would have taken too long, but I think that rise of civil liberties, civil rights, Rizal, Laura Weinrib have helped begin to tell that story very well. It is coincident with this period as well, as a response to some of those limits. But Karen, I'd love to hear more from you on that as well.
I mean, I'm really glad that the question came up the way that it did in the Q&A. And I would just say, I think Bill he now has just reams of students out in the world. And I think some of your students, their work kind of speaks to this question. I'm thinking of Kathy Cahill's work on what was happening with, federal regulation of Native Americans and the way that's pioneering these technologies of modern governance, but in a really different context. So, I wonder if, I've always said that your books kind of launch more conversations. They don't close off conversations, they open them up. And I think that there will be a generation of scholars that might, tell this story differently in a way that, sorry, my lights went out just now, in a way that, I think you're saying that if you had more time, you might have laid it out differently. In your introduction, you do say that, there's a substantive vision of democracy that is always constrained by conceptions of the circle of we. I don't think you put it quite that way, but, there's a vision of who's included and it's contested. And I think there are people who haven't yet expanded that circle probably beyond white people, and that's work that would have to be done, I think, using some of the groundwork that happens through that reconceptualization of citizenship, right? So I think there are tools in the toolkit that can be used to make this more expansive. Maybe in the progressive era, it's narrower than we would like today.
And just to add, the question raises a wonderful methodological issue that came up in the symposium organized by the Yale Journal on Regulation on your book. And it's my ambition to have someone convene a symposium on something I've written someday, and maybe it'll happen, but it's a credit to you that it does. But history always has multiple threads. And so the question is, you're creating a synthesis, and the question is, how do we deal with conflicting evidence? How do we think about what is adequate proof? Because there are these other, look, it was the first half of the 20th century in the U.S. There's plenty of horrible things going on. It's just the reality of it. But in addition, the methodology of your book is a history of ideas. It's a history of historians and thinkers. So in a sense, we're actually digesting another layer out from the actual, ground activity. And so
Bill, is it a history of ideas? I feel like this has been just a kind of debate actually in the symposium, is whether we should think of it as exclusively an intellectual history. And my reading, Christopher, is similar to yours in that he is focused on thinkers, but they're thinkers who actually do stuff in the world, right? Like they're writing like railroad regulation reports and stuff. Bill, what's your response to the intellectual history point?
I mean, that's how I would like to see it. Like I use intellectual history so that I can frame the synthetic story. But these are not just ideas, and they're not just books. I've been accused of writing history by the book. The great thing that I sort of discovered in legal history that you all know, the move towards law is that legal ideas are not just ideas. They're ideas in action. And so I've always been drawn to, the kind of books I'm drawn to are treatises or reports that are syntheses. I have to use syntheses because otherwise, as Christopher knows, you're not going to go through all of the public utility reports from 1880 to 1930. It is humanly impossible. And so I like to use these kind of digests and treatises, which are about, Wyman but there are new ideas there are fresh ideas, but boy, is he processing a mass of case law. And those are ideas in action. Those are ideas with consequences, as Bob Cover says. These are legal ideas that have, all kinds of consequences in the world, as opposed to being just an abstract kind of intellectual debate. That said, I would just add another thing that, when you're doing a synthesis, there are always choices you have to make. And Karen, I liked I do sort of try to write things that will open up topics rather than close them off. And so I'm always drawn to, well, what isn't being treated well in the established historic literature, and things like public utility. I just didn't see as much as I would have liked to have seen in that space. The way I talk about social regulation, I think, is quite different. Citizenship, now there are lots of people there, but I started long ago and we were all talking together. But those were things I think that needed to be opened. Two other topics that you couldn't get a whole history of this period without introducing would be war, right, and the impact of war on this period, and empire. And I just couldn't do, those. We have, thankfully, some really terrific historians focused exclusively on the role of war and the role of empire. So it's never my objective to suggest that war and empire are not important to this story. They're very important, but I did have to make some choices about what other people were already doing, what they were seeing, what we're not in danger of losing in the historiography versus these other things that, I had a kind of comparative advantage perhaps of kind of going in and pulling out.
Okay, in the interest of time, I'm going to try to combine two more questions from the audience into one, and then I will close out with one last question of my own for each member of the panel. Okay. But the final combined question from the audience is to reflect on what this history that you've unearthed means for modern day administrative law debates. One questioner points out to the debate between independent agencies and the unitary executive, in which it's argued that the president provides a more democratic institution than these independent agencies. Another question focuses on the major questions doctrine, where the court recently has said, well, gee, if there's big value choices that have to be made for very consequential policies, it needs to be clearly made by Congress, because that's more democratically accountable than by agencies. So does your history suggest that no, maybe these agencies actually are more democratically accountable, or have a greater democratic pedigree of some sort than perhaps these modern debates in administrative law let on? And I invite comments from anybody, because I know you all are interested in administrative law issues.
So Christopher and Karen, I'd love to hear from you first on that, if you.
So I'll go first. What I find myself fascinated by is how the reception of the legal process school has changed over time. We used to say, give it to the legislature, and now we understand that all bodies have their pathologies. And we've morphed into a much more plural idea of what, to borrow your phrase, Bill, what democracy means. There is you mentioned mayors, elected mayors aren't necessarily democracy. And I think that skepticism is carried through a lot of different ways. So what I think your work suggests is not a search for a single monolithic answer, but rather a process-based dynamic tension of multiple actors that would not be static over time, that might create different solutions, situated solutions that might change as we need it.
I think my reaction to that question is is pretty similar. And I like that your work opens up just different ways of thinking about democracy. It seems like and Bill, we were talking about this just with some other folks at a conference this weekend about how, current Supreme Court doctrine has helped kind of narrow our vision of what democracy means and where we look to it, and what are the only sources of democratic legitimation. And I think your work, again, opens up a different way of thinking about that question. Now, whether that would actually catch on in today's Supreme Court, I think is kind of a different matter. So I think something that's interesting about your work is you're kind of rooting the modern administrative state in the progressive era. And you could say there's more of a fetishization for the founding era. And so, is your work somewhat in tension with the preferences of the current court, would be just like maybe a question I would throw back to you as you reflect on this really good question from the group.
Well, it's interesting because as a historian, you have such a unique perspective on these types of questions. And, after spending all this time in this period with the pragmatists and with the realists, and, the notion that, at least at a certain point in the history of legal education, the line was, we are all realists now. We are all legal realists now. And I had the pleasure of presenting part of this at Yale Law School earlier this semester, at the very beginning of the semester, actually, and a student stood up and started with the phrase, well, but of course we're all originalists now. So, and so I kind of, I think that's why it's important to really take account of these different eras in history where people just thought fundamentally differently, and that our conventional wisdom, I do think, I just sense an impatience with the status quo that is palpable. I mean, the reason, Lina Khan's breakthrough work on antitrust received, it was just a new way of thinking after a period of kind of pretty staid orthodoxy about thinking of particular questions. The reason the law and political economy movement, I think, is getting so much traction is because it's a site of new ways of thinking. Doesn't mean they final answers on these questions, or public utility always holds the best model for addressing some of our most pressing public policy issues in areas like tech and the like. But it offers some alternatives. And I think there was a period of time, David Graywall, Jed Purdy talk about, I'm not totally convinced by the power of this neoliberalism, that there's a kind of neoliberalism idea that takes hold in law. I will say their notion of a period dominated in kind of law and thinking about public policy alternatives in which there was no alternative or very small alternatives were being considered does characterize the last sort of 40 years or so of American legal history. And I think there's increasing impatience with the limited range sometimes of options that we can consider, that the best we might be able to do are technocratic nudges around the edges, maybe make cost-benefit analysis a little bit more, I think we're seeing that in our in across the legal academy and the policy communities today, a search for new answers, and the past doesn't provide them for all the reasons we've discussed, but in any kind of finality. But I do think this kind of notion of opening up some possibilities that have been foreclosed for all kinds of reasons is a good kind of pedagogical endeavor.
So one last question in a lightning round. I'll ask each of you to offer one lesson or one thought that you want to leave the audience with about the book. And maybe we'll go in reverse order. I'll start with you, Professor Yu, and that will leave Bill with the final word.
That we, I would say, imposing modern structures on history is a hazardous venture, and that understanding on its own terms is critical.
Thank you.
My final thought would be, I think the book gives us a different vision of thinking about how much the state can do for the public interest, and maybe it's time to reclaim that, not exactly in the way maybe it was done in the past, but we could have this affirmative vision of governance in the public interest again.
And I would just very quickly concur that, as of June of this year, America's history and tradition has risen to new heights of significance in constitutional jurisprudence, and I would just urge us to make sure that history and tradition that we deploy is based on social fact rather than mythology and fable. And actually, Friedrich Hayek is one of the first persons in a book, Capitalism and the Historians, who insisted on that, right? Separating out historical fictions and fables and myths from the social facts, the social realism, on the ground.
Well, I want to add my own thought, which is to urge everyone to read the book. I hope everyone participating has enjoyed this discussion as much as I have. I do know we've had some comments where people have said how terrific they think this conversation has been and how they are going to go read the book. So that's gratifying. I want to thank each of our panel members for taking the time to be with us today. Obviously, biggest thanks of all to Bill for writing this magisterial book that has brought us all together and for helping set us straight and opening up, as Professor Tani said, opening up a lot of conversations. And I hope this is just the first of many that we will have on these issues going forward. We have recorded this session. It will be on our YouTube channel. So feel free, once it's posted there, to share it with anyone else. I want to thank everybody again and wish you all a very good evening. Take care.